Hello guys, and welcome to another episode of my lecture. On today's episode, we are going to talk about the fact of the case of Benard Longe versus First Bank. In my next class, we are going to talk about the argument that was advanced before the Supreme Court on this particular case, and then in the third lecture, we are going to talk about the Supreme Court judgment on this case. So today, just talking about the fact, let us go straight to what the fact is. The appellant was managing director, and after an improper grant of loan, he was suspended, and then subsequently his appointment was revoked. He wasn't given notice of meeting at which decision to terminate his appointment was taken, and thus he sued that he was entitled to such notice under section 292, then section 260 of the old CAMA, that's 1990. And fracture to give him notice rendered his termination null and void. Now, very quintessential to the fact are those letters that were sent to him, as well as the extract of the meeting that purportedly removed him. So let us start with the first one. What can we find in the first one here? This is the letter of suspension. You can see that it is dated 22nd of April 2002. And then it states, I regret to convey to you the decision taken by the Board of Directors of the First Bank Nigeria PLC as an extraordinary board meeting of 22nd of April 2002 held at Kamai's house, Abuja, to suspend you with effect from today, 22nd of April 2002. During this suspension, you are expected to concentrate on the recovery of the credit facility granted to the Investors Group Nigeria Limited. The board expects that you will do your utmost best to help in the collective efforts towards the recovery of the money. Signed, Alhaji Dr. Mutalab, CON. Now, we then go to the second one that was adduced before the court, which is an extract of the minutes of the meeting at which the appointment of the appellant was terminated. Don't forget that the previous one was not a termination, it was a suspension, and it was done in April. Now, this extract is dated 13th, which means April, May, June. 2 months later after his suspension, they met at an extraordinary board meeting to remove him as the managing director. Do you understand? And it is titled Extract from Minutes of the Extraordinary Meeting held on 13th of June at Abuja on revocation of the appointment of Benard Longe and Uzoma Nwankwo from the board. Now, the board reflected and pursuant to Article 105 of the Memorandum and Articles of Association of the Bank, resolved to revoke the appointment of Benard O. Longe and Uzoma Nwankwo from the board as managing director / chief executive and executive director respectively. Now, note that this case regarding Uzoma Nwankwo is not in this particular one. Do you understand? I think that is another case entirely, but this one is just basically on Benard Longe. However, at this point, we should have an idea as to the removal of Uzoma Nwankwo, because at the extraordinary meeting of the board, not of the general meeting, extraordinary meeting of the board, they purported to remove Uzoma Nwankwo as an executive director. The question is, do they have the power to do so? Well, we can only speculate by saying no, citing the authority of Iwuchukwu versus Nwizu, which gives the power to the members in general meeting. However, contrary to that, they can actually be a separate contract between Uzoma Nwankwo and First Bank as to how determination can go, or stipulated in the articles, which we do not know about. Therefore, we are not abreast with all relevant facts regarding that case. So moving on, this purported removal of Benard Longe as managing director was done on the 13th of June, 2 months after he was suspended, signed by Tijani M. Borodo. Now, on that same day, a letter conveying the decision of the board of directors to the defendant, which was dated 13th of June, was sent to Benard Longe. It was titled Revocation of Appointment as Managing Director of First Bank PLC. And then it says that I write to advise you that the Board of Directors at its meeting on the 13th of June 2002 has resolved to revoke your appointment as managing director. Consequently, your appointment is hereby revoked with effect from the date of this letter, which is 13th of June. And that was sent by Dr. Mutalab, who is the chairman, and then a copy by Mr. Ajekigbe, who is now the new managing director of the bank. His claim that he was removed as managing director, not in accordance with the law, was dismissed by both the trial court and the Court of Appeal, and therefore he had to appeal to the Supreme Court. In my next class, I am going to explain the basis of the argument of the plaintiff before the court in its judgment, as well as the argument of the defendant, who in this case is First Bank. So I'll see you in my next class.